Hi, it's Anne-Marie from Charmed Life Therapy again, back with another update. and this one kind of could appropriately be titled, as I saved a recent PDF from the docket, as 449 Blake bitching and moaning about tag, which, you know, I feel the meanness coming up in myself, but I think it's because it's like you can mess with Wayfarer, all right, Wayfarer had something to do with you, but all of these other people you're coming for now, these people just have their own personal opinion, which they're entitled to. But basically, Blake's latest filing, and God, I was going to bed last night and there was about 7 emails and I thought, oh my God. But basically, she now wants to blame tag. So I'm going to do a little bit of reading from the documents, but she kind of wants to blame tag for not giving her sufficient information in her interrogatories, which is now why she's having to send out these waves of subpoenas, if you like. So that's not her fault. But why? And she gets very specific. So I'm going to read it, and hopefully my little doggy down here is going to be good while I do. So this, and we've also interestingly got we've got Lauren's letter, Lauren Nidy, court of random opinion. We've got her letter of intent that she's going to file a motion to quash. We've got that, and we've also got Cassidy O'Connell's letter, or the letter from her company on behalf of Cassidy. So Cassidy was the one that the other day, and I don't know whether, I haven't watched some of Cassidy's videos because they're very long, and I don't want to get so sucked into this thing that it's my whole life, so I haven't got hours and hours that I want to devote to it. But I have a feeling that she maybe filed this initially as wanting to be anonymous, or from what she's saying on this letter, I get the sense they were testing the water to see if they were allowed to submit anonymously, because they feel like they should be, that they shouldn't have to be exposed, being a third party, not being a litigant or a defendant or anything like that. It's like, why am I not entitled to privacy? So in my understanding of this letter, it seems a bit like they were testing the waters with that, and the judge kind of clamped down and said, no, nobody gets to be anonymous in this court. You have to tell me who you are. It's a matter of public opinion. And they make some very good points in this letter to Cassidy, or Cassidy's legal person. It's probably a bit of both. So let's start with Blake's bitching and moaning about tag, also known as 449 on the docket. So let's have a read of this one. So, dear Judge Lyman, Plaintiff Blake Lively writes to respectfully request that the court compel defendant, the agency group, which Melissa Nathan's self-proclaimed reputation management company, that's rather nice, isn't it, to de-designate as confidential and attorney's eyes only tags June 25th second supplemental responses and objections to Ms. Lively's first set of interrogatories, the interrogatories and tags responses, the interrogatory responses. The interrogatory responses identify individuals and media outlets with whom tag communicated about Ms. Lively and topics related to this lawsuit. This information does not constitute trade secrets under the party's current protective order, as tag claims, and the designations are thus improper. So it's attorney's eyes only at the moment, tag's responses to Blake's interrogatories. And she continues to write then, the court should not permit tag to manipulate the discovery process to perpetuate the same harms that got it sued in the first place. So she's again going back to this thing of defend, attack, victim role reversal and all the rest of it. She's bringing that back into the thing, saying that you're continuing to abuse me by designating this attorney's eyes only, so the public cannot see how I am being victimized. That's basically what she's saying, and I can't show the public who you're victimizing me alongside either. So a core component of Ms. Lively's claims centre on the defendants and cross-complainants, Wayfarer Studios, Justin Baldoni, Jamie Heath, It Ends With Us LLC, Melissa Nathan, Tag, Jennifer Abel, Steve Sarowitz, collectively digital media smear campaign, which sought to manipulate the media landscape using untraceable sources to paint Ms. Lively as the aggressor instead of the victim. Seemingly unable to abandon this playbook, Tag's interrogatory responses yet again attempt to bend reality to the Wayfarer party's ends. Interesting, isn't it? On March 14, 2025, Ms. Lively propounded the interrogatories on Tag, seeking the identities of online personalities or content creators and others with whom Tag communicated about Ms. Lively, Mr. Reynolds, the CRD complaint, the actions or the Lively Reynolds companies as defined in the interrogatories. Specifically, interrogatory number 5 asked Tag to identify all content creators with whom you have communicated in any manner concerning all of the things, including the complaint, any companies, the digital campaign, from May 1st, 2024 to present. On June 18th, Ms. Lively propounded similar interrogatories on Heath, Baldoni, the movie company, Abel, Wayfarer, Sarowitz and Nathan, and those responses are due on July 18th. After Tag was ordered to respond to the interrogatories, Tag supplemented its responses, identifying a number of individuals who have spoken publicly about Ms. Lively and this lawsuit, apparently at the behest of Tag and the other Wayfarer defendants. Case law quoted, despite the factual nature of this information, Tag unilaterally designated its responses as confidential and attorney's eyes only, thus obscuring Tag as the source of this information and allowing the Wayfarer defendants to once again recast Ms. Lively as the aggressor in pursuing subsequent discovery, which is exactly what has transpired. During meet and confer discussions, Tag's counsel primarily claimed that its interrogatory responses constituted trade secrets, which if disclosed could somehow harm Tag's business. Not so. The protective order limits confidentiality and AEO designations to non-public material, the public disclosure of which will cause harm to the business, commercial, financial or personal interests of the producing person and or a third party to whom a duty of confidentiality is owed. The protective order further limits AEO designations to confidential discovery material of such a highly confidential and personal, sensitive or proprietary nature that the revelation of such is highly likely to cause a significant competitive, business, commercial, financial or privacy injury to the producing party. And while trade secrets can be designated as confidential and AEO, those protections are diminished for confidential strategies and other information related to the parties to this litigation. Tag's counsel has provided no facts to support their assertion that the identity of third parties could somehow constitute trade secrets. Blake's very good at providing no facts for things either. The no facts as to why she thinks Google should hand over all the content creators' information. There you go. So Tag's counsel has provided no facts to support their assertion that the identity of third parties could somehow constitute trade secrets, nor can they explain how this information could be so sensitive as to cause harm to Tag, especially where many of these individuals have already spoken publicly about Ms. Lively and this case. Indeed, the information Tag has designated as confidential and AEO all relates to Tag's work for the Wayfarer parties themselves. Tag's confidential and AEO designations are therefore plainly improper, and the court should order Tag to de-designate them. Moreover, these misdesignations are having very real impacts. For example, if Miss Lively issues subpoenas related to individuals identified in TAG's interrogatory responses to marshal evidence about their involvement in the smear campaign, she will be hindered in her ability to meet and confer or respond to questions, and will be unable to explain to such subpoenaed parties that the discovery directed towards them is based in part on the fact that TAG identified them. Content creators who have been the subject of discovery have already painted Ms. Lively as the aggressor in this lawsuit. So this is kind of interesting, isn't it? This is where she's saying none of this subpoenaing of all of you on YouTube and X is my fault whatsoever, because, you know, I have got no information. You know, I cannot do what I need to do lawfully, kind of in a way, or through straightforward means. So that TAG is forcing me to do it in this manner because I know they have colluded with TAG, but I cannot get TAG to basically admit that publicly, so that the public do not talk nastily about me and upset my feelings. That's basically what it is. But I very much doubt that in these responses to the interrogatories, it's going to say that TAG has communicated with Lauren Nidy and Popcorn Planet and Dave Neal or whoever else. You know, Dave Neal hasn't been subpoenaed to my knowledge, that was just off the top of my head, but, you know, Cassidy, O'Connell and the rest of them, because they're all vehemently saying they have had nothing to do with any party related to this lawsuit. So who is she alluding to? So let's continue. So she's already been painted by these content creators as the aggressor in this lawsuit and have drawn a false equivalency between her discovery efforts and the Wayfarer Party's alleged smear campaign. One subpoenaed content creator even went so far as to record a call with a receptionist from Ms. Lively's attorney's office without express consent. I have a feeling, didn't Andy, when he did that, didn't he say that he was recording it at the beginning? I remember watching that video. I thought he said he was recording it. I thought he did. I could be wrong, but I have a feeling he said he was. So he did actually let them know, to my knowledge. So record a call with a receptionist from Ms. Lively's attorney's office without express consent, and then posted the recording on YouTube. See Popcorn Planet, it's real. We called Blake Lively's lawyers. They lied to us, and the link to the recording. This content creator further used the recording to make false inflammatory remarks about Ms. Lively and her counsel, and is seeking to fundraise based on the recording and his remarks. Now that is not fair, because he's not fundraising, just he's saying that basically if there's no force involved, is that it's not like he's saying if you want to see me vindicated, you need to support me, you should go off and donate like that. He's leaving it completely open to all of the people out there that feel a bit outraged about all of this, that are happy to kind of give him $5-10, whatever it is they can afford, because they can just see the injustice in it all. She's wording it to sound like he's created like a purposeful money-making venture, to my mind. The bottom line is that the concern about being hamstrung and being able to tie her discovery to the Wayfarer Party's discovery responses further exacerbates public backlash against Ms. Lively, which is the real thing that she's totally bothered about, the public not liking her, which she should not have to endure when there is no conceivable privacy interest that TAG and others are protecting. History is now at risk of repeating itself because of TAG's misdesignated interrogatory responses. Ms. Lively is yet again being forced to battle an untraceable campaign. Unable to, if it's untraceable, how does she know it's Popcorn Planet and Cassidy O'Connell and Lauren Nidy and Ashley Brianna Eve if it's not traceable? She reckons this is what's in TAG's interrogatories that can't be, that they're refusing to make public, so that the public backs Blake, apparently. You know? Unable to defend herself against misinformation online, while TAG may have been able to obscure its contacts in connection with the initial smear campaign, So that's saying that she's nothing there. There's no evidence there because it's not there. They can't find it. They've successfully hidden it. It cannot do so here. For these reasons, Ms. Lively asked the court to compel TAG to de-designate its interrogatory responses as confidential and attorney's eyes only under the parties' protective order, and make clear that any similar confidential and AEO designations the other Wayfarer parties may seek to use in connection with the interrogatory responses due on July 18th would likewise be improper. Respectfully submitted, Ezra A. Hudson. So again, it's interesting, isn't it? It's this thing of you don't get to protect anything, but we get to protect things. You don't get to know all about my financial information, but I get to know all about your financial information. So kind of it's a little bit interesting that, because it does kind of tend to make you wonder, well, what is in TAG's interrogatory responses? Who have they said they have been in connection with? Who have they spoken to? And the thing is, it kind of been like spoken to in passing, like somebody's asked for a comment and they've given a comment, but I still don't think it's any of the people that we're here all following on YouTube, because I totally believe that they would have said, because being independent people, you've not got that backing. If it all goes tits up, you have to be true to your word, because if you're going to get called on it, you can't afford like a hefty lawsuit. So I honestly don't believe that TAG was in touch with Andy from Popcorn Planet and the rest of these people. What did they have contact possibly with Perez Hilton? Maybe, you know, that's entirely likely, although I don't think that he's saying anything like that, but he may have approached them for a comment in general journalistic ways. I don't know, but it's like, who are these names supposedly? Because I honestly don't think it's these, certainly not these people on YouTube. Maybe it's some of these on X that I'm not as familiar with, because I'm not on X. So let's kind of read Lauren's letter next, because that's kind of a quickie. So this is Lauren Nidy, Court of Random Opinion, who is best buds really with Omar, the tilted lawyer. But it's so nice, like people are all interacting with each other now. So this is Lauren's letter of a notice of intent to file a motion to quash in Lively v Wayfarer. So, dear Judge Lyman, I'm writing to formally notify the court of my intent to file a motion to quash the subpoena issued by Blake Lively to Google LLC, served by Ezra Hudson of blah blah. I am a non-party independent content creator operating the YouTube channel at Lethal Lauren 904. I have no affiliation with any parties involved in this case. My forthcoming motion to quash will be accompanied by a detailed supporting memorandum based on the following grounds, and this is really good. Violation of First Amendment rights. My commentary about matters of public concern is constitutionally protected. Plaintiff has failed to demonstrate any valid evidentiary basis justifying the infringement of my right to keep my personal information anonymous. Stored Communications Act violation. Google lacks my consent to disclose my personal subscriber information and communications. 3. Improper issuance under FRCP 45C. Plaintiff's subpoena was improperly issued, as she likes to do, improperly issue subpoenas, from the Southern District of New York, exceeding Rule 45's geographic limits, since compliance is requested from Google LLC, which is located in California. The law in Blake's eyes seems to have no boundaries. How many times has she been pulled into account now over this jurisdictional thing? You know, she's just had, hopefully this case, Jed Wallace dismissed out of her lawsuit. That's still in play kind of thing, figuring out where that goes next. But, it's not the first time she's tried to file subpoenas on people that are under entirely different jurisdiction. It's happened numerous times now, and she's not getting the message. And the fourth point in the letter is unduly burdensome and overbroad. The subpoena's expansive request for personal identifiers, financial, geolocation, and other sensitive data is irrelevant, disproportionate, and designed to harass and intimidate. And the last point is irreparable harm. Disclosure of my information threatens serious harm to my privacy, safety, and professional reputation. Given these abuses, I intend to seek appropriate sanctions under Rule 45D1, including reimbursement of my reasonable expenses. I will also request a protective order under Rule 26C, barring plaintiff from further similar abusive discovery without prior court approval. I anticipate filing the formal motion to quash and accompanying materials within the timeline prescribed by the applicable rules or as otherwise directed by this court. Yours sincerely, Lauren Nidy. So I thought that was very good and very succinct and made the points well. And it actually sounds quite scary, doesn't it? It's like, take that. And then the last thing I'll read for you today is, so this is Cassidy's letter, or Cassidy's company on behalf of Cassidy, I guess. And this is another good one. So it's basically arguing this point is I'm not allowed a right to privacy for some reason, you know what I mean, and citing case law as well. So dear Judge Lyman, of note, there are no non-party rules for submission in the court's individual practices to refer to when filing with the court. While the court is holding us non-parties to the standard of parties by quoting case law intended for parties in its order, namely, quotes the case law that kind of backs up the fact that people have a right to know who is using their courts. We object to the use of this citation because we are not plaintiffs, nor are we defendants in this case. We are non-parties that have received subpoenas sent to a third party that did not go through the appropriate process to be obtained, and had they would have not met the standard to have been approved. So this is kind of alluding to Van Zandt as well. It's kind of getting a subtle dig in that there's a pattern here of subpoenas not being properly stamped, approved, you know, all of the rest of it. And there's more case law cited, this Highfields case. So the court in Highfields recognised that the First Amendment protects the right to anonymous speech, particularly online, and that unmasking an anonymous speaker through discovery can chill free expression. It therefore adopted a two-step test for when a party seeks to unmask an anonymous defendant. So step one is the plaintiff must provide a prima facie case before the court by presenting sufficient evidence to establish an essential element of their claim, just as they would need to survive a motion for summary judgment. And step two, if a prima facie case is made, the court must balance the strength of the case and the necessity of the disclosure against the speaker's First Amendment interest in maintaining anonymity. I was not afforded this standard. Subpoenas were issued from this court not only failing to meet this standard, but failing to meet any standard. There is no evidence or sound legal basis whatsoever to have issued this subpoena in the first place. Our objections have been clearly noted in our motions to quash that so far have not been allowed into the docket. All we need from this court is a stamp. Once we receive this, we can forward it to the third party that was subpoenaed for our information. This court's demand for our unmasking goes against our First Amendment rights. We would not be in this position if the court had not allowed such a wayward subpoena in the first place, and yet the court demands our unmasking in a case that the entire world is watching. How dare this court! Exclamation mark. And then there's a quote from this Highfields case. When word spreads that people who have committed no wrongdoing can have their identities disclosed through civil discovery, this kind of chill can be fatal to the use of the internet as a vehicle for free expression. What is the internet if it's not a vehicle for free expression? There are many cases supporting my stance in my position as a non-party whose information has been subpoenaed by a third party. These are the cases that apply to me, and there's a couple of cases there where the court reaffirmed the Highfields two-step test requiring plaintiffs to show a real evidentiary basis for alleged wrongful conduct before proceeding to balance First Amendment interests. More case law quoted. where the court denied unmasking, where the plaintiff failed to present sufficient evidence satisfying the first Highfields prong, that two-step test, thus not proceeding to the balancing step. Then more case law. Foreign discovery context. The court cited Highfields to emphasise that allegations and speculations without evidentiary support are insufficient. More case law. The court applied Highfield's balancing test and found that Doe did not present sufficient evidence to overcome the strong First Amendment interest in anonymity. And then more case law, where the Sixth Circuit applied Highfield's style balancing and denied unmasking, where harm to anonymous speech outweighed the plaintiff's interests. And this case does seem to be an awful lot about Blake's interest, doesn't it? Even more compelling, Sony Music Inc. vs. Doe's 1-40. In this case, Sony filed suit against dozens of allegedly infringing users on peer-to-peer networks. To identify the alleged infringers, Sony sought to subpoena internet service providers to reveal subscriber identities. The court adopted a multi-factor test similar in structure and underlying purpose to the Highfield standard for evaluating whether to allow the disclosure of anonymous speakers. Sony's test went beyond the Highfield standard, requiring the requesting party to demonstrate a prima facie claim of copyright infringement, actual evidence beyond speculation, that the subpoena is sufficiently specific to identify only the alleged infringers. And as we said, I don't believe TAG in those responses to the interrogatories has said they communicated with Cassidy O'Connell, Popcorn Planet. I doubt it's Candice Owens, possibly, I don't know. Any of these other smaller ones like Ashley Brianna and all of that. That there is no alternative means to obtain the information. A central need, well, if she's saying that TAG have it as well, why does she need it from the content creators? If she knows that TAG knows who these people are, why does she need it from these small content creators? A central need for the information to advance the plaintiff's claim, and a consideration of the anonymous speaker's expectation of privacy and First Amendment interest. The subpoena issued from this court for my information fails at every level of this test established in this very court. The law recognises that in order to request this information, a subpoena is needed, yet this court demands I readily supply it as if this subpoena has already been granted. It has not, it should not be, and it should not have even been issued. The error lies with this court that demands I bear the burden for its mistake. I mean, I don't understand all of these jurisdictional elements, but it's like some of these people are in Canada, aren't they? And has Blake gone to the Southern District of New York to issue subpoenas to Google in California for information from people in various other countries? Basically, I don't get how this all works out. I don't pretend to. Your responses, aside from telling us you will not entertain any anonymous filing, can't say anonymous today, but this is like a direct, Judge Lyman, your responses, aside from telling us you will not entertain an anonymous filing, have given little information to go on to respond to a subpoena that issued under the authority of your court. For example, 3 of us have submitted 2 motions to quash, 1 letter of intent, yet the court did not clarify which one needed de-anonymised. Kindly address us by the names on the wayward subpoena so we know which submissions need altered, as our time to respond is running short. Because it's ridiculous, isn't it? They've got hardly any time to get these things in. It's like if you didn't have a lawyer or someone you knew or could instantly go to someone and say, help me out with this, you'd waste a couple of days just trying to figure out who to get to represent yourself. And then this letter continues, because we are at the mercy of this court in spite of how much we object to the way in which we have been brought into it, I have resubmitted mine on July 17, including my name, position with the company that has been wrongly subpoenaed, address and telephone number. Do you require more than this? If so, I need further clarification. An additional, I love how we're talking to the judge in this case. It's like, fuck you. An additional purpose of this letter is to inform the court that multiple non-parties who were served this ill-gotten subpoena are filing a complaint today with the California State Bar against Ezra Hudson, the attorney who signed it without the appropriate requirements of presenting a prima facie showing before the court, passing the two-prong standard of Highfields required to unmask our First Amendment protected rights to publish anonymously on the internet, and without domesticating it to the appropriate court in Sacramento, California, where Google is located. The contents of this complaint are found in Exhibit A. It's amazing, isn't it? Ezra Hudson and the other company that was involved in the Van Zandt. It's amazing how they can just ride roughshod over the law and issue these subpoenas that aren't signed off, stamped, justified. It's amazing, isn't it? And then they can argue so eloquently about why they're able to do it and how lawful it is. So the letter continues, on what legal basis were these subpoenas issued out of this court? Was any, capital letters, evidence at all presented to validate them? Or is Ms. Lively free to submit just any subpoena to anyone that is not her fan? Ms. Lively has been gratuitously allowed to extend her witch hunt for discovery in which she has no evidence to support, and has amended this same subpoena to add members of X on July 17, 2025. Accordingly, more complaints and motions to quash will follow. The information she seeks is easily obtainable from the actual parties to this case who have the privilege of being legally represented when dealing with overbroad, inappropriate subpoenas. At this time, we are drafting a complaint against the court as well. Regards, manager of Cassidy O'Connell LLC. So yeah, pretty impressive, wasn't it? And it's exactly kind of what I said. It's Blake now wanting to blame Tag for why she's had to subpoena these content creators, that if Tag didn't have an attorney's eyes only designation on those interrogatory responses, then she wouldn't be forced to do this to all these little people who are now so offended by her and are talking to their audiences and creating a further campaign of defamation against Blake Lively, making her victimised all over again. But once again, these actions, these behaviours are absolutely nothing to do with Blake Lively. It has to be somebody else's fault. But why is she? If Tag holds the answers and they've seen that, but they just can't share it, but they've seen it, so why do they need to subpoena all the small content creators? They don't need to, because they have it from Tag. They just can't show the public is what they're complaining about. But they don't have it because these small content creators are saying we've got nothing to do with it. So why is she going after them if it's not harassment and intimidation and just a desperate quest to make something stick? It's like she can't believe, like people like Cassidy O'Connell, like Without a Crystal Ball, you know, some of the ones that have gone more in depth on the legality, some of the ones that claim that they have sources. She can't believe that they've just spent an awful lot of time reading an awful lot of stuff and looked between the lines and maybe talked to a person who knows a person who knows a person. It has to be, no, you're getting that directly from Wayfarer, you're getting that directly from Brian Friedman. It can't just be that enough people out there just have not liked Blake Lively's behaviour and they're finally grouping together and doing something about it, being led in a way by these people that are willing to spend hours of their time and thousands of pounds buying these court documents and stuff. You know, it's like I look at it and think, I'm not paying for that stuff, but people like Without a Crystal Ball are paying for all the court documents and doing you the favour of unpacking them for you, you know, so that you don't have to. And that's the thing, and that's what Blake is still really, really struggling with, that she really cannot get over, that it all boils down to her, and that she is still now doing the same actions that got her into trouble in the first place, that it is all her, it's not somebody else. And that's the thing about narcissists, and why life is really hard for a narcissist, because they have an inability to learn from their own actions. And that's literally what you're seeing, in my opinion, that's what you're seeing playing out here. I don't believe any of these small content creators or Popcorn Planet or any of these have been colluding with Tag or Jed Wallace or any of these things. It's like I keep coming back to, I got into this case because I saw that press tour for the movie and thought it's really weird that the lead actor, where is he? It's like everybody else is there. Where's the lead actor? It was so odd. Everybody's attention was peaked. I wasn't off looking at a million X accounts or anything like that, or doing a deep dive. Then I saw Kirsty's video because she saw the weird press for events with us and thought, oh yeah, I remember that weird interview I did with her. Let's repost it. It went viral. We all saw it. Then a couple of other accounts, found other videos. It wasn't like, it was organic. It literally was organic. It was everybody just thinking, oh yeah, I remember that weird thing too. What was that again? And just going and finding it. It wasn't Jed Wallace and 1,000 bots and all of the rest of it. It's like I said before, I don't read nonsense accounts. I don't read anything that looks obviously AI. If I see a point, and I think most people do this now, if you've got any sense, if you read a comment and it's quite inflammatory or threatening or whatever, what you might do is quickly check the account, see how many followers it has, if it looks genuine, if the photos look real. And if it's not, then it's not worth taking on board in your own mind, don't you? You know what I mean? You just show a bit of sense. I know that everything I've done has nothing to do with bots or smear campaigns or seeding comments on a feed. It's not often I read like a whole stream of comments to influence my thoughts on these things. And I think everybody covering this was the same. They were looking at direct information like first hand or second hand stuff. They weren't going 10th hand, 11th hand, 12th hand. It was like the immediately available stuff that you didn't have to read a whole comment thread for. So yeah, it just boils down to, she doesn't like, that we don't like, that she's subpoenaing little people. So now she has to go back to Tag and say, you don't get to have attorney's eyes only designation on that because it's making me look bad. That's basically what it is. But it's her that's making herself look bad. And there's that lack of accountability all over it again. So anyway, I hope that was useful. Obviously it was a bit longer than usual. Please do hit that like and subscribe if you're enjoying this content. And I will see you again soon. And also please always do check my description box because there's links to free resources in that for my day-to-day job where I'm a rapid transformational therapy practitioner. I usually help people that are kind of like these small content creators that have had a hard time, the self-esteem has taken a hit, or they're feeling unheard, unseen, vilified. I help people break the chains of oppression or of not having a voice or of having success blocks, money blocks, things like that, feeling not good enough, feeling sat on and all the rest of it. That's my day-to-day job where I transform people's lives, and I always drop free resources in the description box. So please do have a look for that, and I will see you again soon. Bye bye.